Josh Eidelson is on the line with us, reporter with Businessweek, businessweek.com. His personal website, Josh Eidelson, EIDELSON.com. Josh, welcome.
Thanks for having me back, Tom.
Yeah, it's great to have you with us. I find this story fascinating that you're reporting on how Amazon is saying to its workers, we want to check you out and make sure, correct me if I have any of this wrong, we want to check you out and make sure that you're not walking out of our warehouse, particularly with something small that has a high value, because they sell a lot of things that are small and very expensive, from electronics to jewelry. We want to make sure that you're not just trying to sneak off with something. And so you're going to have to go through a security screening when you quit work every day. That security screening can take up to a half hour, and we're not going to pay you for that time because we consider that the equivalent of commuting time. Do I have that right?
Well, these are, as you suggest, workers in Amazon warehouses. The workers in the original suit are on paper not employees of Amazon. They're employees of Integrity, a staffing company that supplies many of Amazon's warehouses, although the plaintiffs have since tried to add direct Amazon employees to the suit as well who go through the same thing. As you say, standing in line, workers say it can be up to 25 minutes every day after work, after they've clocked out, and not getting paid for it. And right. Amazon's position, backed up by the business lobby, backed up also by local and federal government, Obama administration amicus briefs, their position is this is not what in the Fair Labor Standards Act jurisprudence gets called integral and indispensable to the work. And so, like commuting, it's too bad for you that you give up that time.
But when you commute, you have at least some modicum of choice. I mean, you can live nearby or you can live far away, and employees, when people either take a job or decide to move, they tend to do the math around that. What's it going to cost me to commute versus what this job pays, and is it worth it? And, 2 hours on the road every day or 20 minutes on the road every day, there's a certain level of control that the employee has. When you're leaving work and you're subject to a security check, you have no control over that, do you?
That's right. Amazon or Integrity does not require you to live, say, 25 minutes from the job.
Right.
Your boss is requiring you, in this case, to stand in line for that time.
Right.
And it's a condition of employment, if you want to keep your job, that you stand and wait and then go through.
So tell me about the knife sharpening. We got the commuting metaphor. What's the knife sharpening metaphor?
Well, so this goes to a pair of Supreme Court cases in the 50s. This is actually an issue, not security checks, but this question of, well, what is work? Is work about producing something for a company? Is that the only time you're working? Or are you working whenever you're subject to that authority, where someone gets to boss you around and tell you where you can go or not go and where you have to do something, or in this case, stay put? These cases go back decades. So the way we get to knife sharpening is first in the 30s, Congress says, if you're suffering or permitting somebody to work for you, you have to pay them. For each hour that they work for you, you have to give them an hour of pay.
Right.
Then in the 1940s, Congress comes back and says, whoa, just to be clear, we didn't mean commuting. We didn't mean what we're going to call preliminary or post-preliminary activities. Right. That then spurs more lawsuits and more legal confusion. And so it's in the 1950s that the Supreme Court issues these two decisions, both of them siding with employees and saying, here are some activities that you do have to be paid for. One of those cases was butchers who were coming in before their shift started, and in order to do the job, had to sharpen their knives. They weren't being given the time to do it during their shift. They were doing it without getting paid. And the Supreme Court said, no, sharpening your knife is integral and indispensable
was that the Warren Court?
To do. So that was in the late 50s.
Was that the Warren Court, Josh?
If
it was the late 50s, it would have been the Warren Court. Right?
Yeah. So in both of those suits, the employees won. The other one involved washing off after working in a battery plant where you might have some lead or sulfuric acid on your clothing. The court said, yeah, it is integral and indispensable to working with those chemicals that you wash off before you go home.
Okay,
and hug
so
your
so
kid.
common sense and precedent would seem to indicate that that this should be a no-brainer, and the court should say this is not unlike knife sharpening or washing off when you're leaving. The problem is that we have a court right now with 5 crazed right-wingers on it who have no problem with not just overturning recent precedent. I mean, Citizens United overturned the 1907 Tillman Act. You know, they went back more than 100 years to blow up legislation that had been repeatedly stamped, yes, certified by the Supreme Court. So am I correct in guessing that there's a fair amount of nervousness around how the court might rule in this case?
I think you are right to think that the workers have reason to be concerned about how this is going to turn out. Both the plaintiffs and workers elsewhere who could be affected. Given that you have a 5-justice conservative majority on the court, given also that you have the Obama administration and the Council of Mayors and other government groups actually lining up behind the companies in this case, and you can also note the difference in who's asking for what. The company side is asking for a broad rule, which would say, and their argument is they don't even want to have to go to court because you know how they hate trial lawyers. They say they don't want to have to ever even go to court and argue about the merits of security screenings. There should just be a blanket rule that security screenings are not integral and indispensable. What the AFL-CIO and others are arguing on the other side is saying, let's just take this case by case. Do something modest, and just in each case have the judges consider the facts and whether at that particular place going through that particular security screening was integral and indispensable. And I think there's reason to be dubious that they will get that from the justices.
Very, very interesting. Josh, thanks for dropping by and sharing your insights with us.
Thank you for having me.
This is going to be a fascinating one to keep track of, and you can read Josh is reporting over at businessweek.com and josheidelson.com. It's always good talking with you, Josh.
Thanks a lot.
Thank you.